Hello viewers, today we will discuss the topic patent issues in digital medium. To understand the patent issue in digital medium, it is important first to understand what is patent and law relating to patent. The term patent is very widely used and that is often wrongly made synonymous with all forms of intellectual property, and it is not quite uncommon to find authors talking about a patent for their book or businessmen in respect of their brand name. In true sense, patents are granted sparingly and only if stringent criteria in terms of novelty and non-obviousness are fulfilled. The term patent originates from the Latin word operate, which means to lay open, that is, make available for the public inspection. The term patent refers to such a document that grants exclusive right to an inventor. Patent may be defined as an exclusive right to use or exercise an invention granted to a person for a limited period in consideration of the disclosure of the invention. Therefore, a patent is a set of exclusive rights granted by the government to a patentee. Patentee is the inventor or assignee for a fixed period of time in exchange for the regulated public disclosure of certain details of device, method, process or composition of matter known as invention, which is new, inventive and useful or industrially applicable. The inventor getting patent is called patentee. The exclusive right granted to a patentee is the right to make, use or sell the invention themselves and to prevent or exclude others from making, using, selling, offering to sell or importing the claimed invention. The scope of the patent protection we will discuss briefly. The scope of the products, services which are entitled to be covered under patent protections are limited, and it is only after the product, service sought to be patented is satisfactorily described as being an invention that represents a distinct advancement or improvement over the present state of art that protection is granted to it under the patent law. Thus, in very simple terms, a patent is a monopoly right granted to a person who have developed a new invention as a result of their own innovation and ingenuity. Such a monopoly right conferred by the statute allows the holder that absolute legal right to prevent others from making, using or selling the service, invention or any product containing the invention for a specified period, thereby allowing the holder the right to commercially exploit the invention and recover to some extent the research and development cost incurred in the developing the invention. In India, patent is the right granted by the government to use his invention to exclude others from engaging in activities such as making, using, importing, offering to sell or selling an invention. It is a monopoly right granted by a state to a person who has invented a new and useful article or has made an improvement in an existing article or a new process of making an article. First, we will discuss what is called patent. A person who invents something may make an application to the patent office requesting to give him a certificate of registration of the patent that he has done some invention and he is the first and true owner of that invention. Such certificate is called as patent. Therefore, right of the patent is created by invention, where an invention is made by two persons. The person who first applies for the patent right would be the holder of the patent. The registration is prerequisite condition to hold a patent right, whereas the registration is not a prerequisite condition to hold a copyright. A patent is used for a limited period specified by law, and after expiry of such duration, anybody else may make use of the invention. Now we will discuss the main requirements of the patent. A patentable invention must fulfill the following requirements. The first is novelty, inventiveness, utility or industrial application, or written description. Novelty. Inventor must prove that the invention is novel and not was in public domain earlier. Mere discovery is not eligible for patent because it does not involve any invention. Second is inventiveness. Invention must involve some creativity and innovation which must add to the knowledge of the society. Another one is utility or industrial application. Invention must be capable of industrial application or should be commercially useful. However, where invention is theoretical having no commercial application, then it is not a patentable invention. Then written description. It should be capable of being described in written form. Where it is not possible, then it is not patentable. Then we will discuss important features of patent. First is it is a license. Then it is a license granted by the state. It is granted in relation to new invention or an improvement in an existing article or a new process of making the article. Another one is it confers an exclusive right on such persons or individual to use or exercise the invention granted to him in consideration of such disclosure of the invention. The invention must be useful or have utility and must be applicable to an industry. It is granted for a limited period. It assures protection for the state to use the specified invention having a monopoly in it. There will be a separate patent for every invention applied for. Depending upon the subject matter, patent can be of various types. The one is product patent. Product patent is a claimed for a product per se and hence cover all the types of products such as machine, electrical gadget and so on. Then process patent. Under process patent, a specific process or method through which a thing is produced or specific use of it is patented. Therefore, the process patent is granted for a particular process or method or production or use of physical thing or product. Process patent is generally given in those cases where the product in question is already known, for a few methods of its own production are known or some uses of it are already known to the society. Then hybrid patent. In this scope of protection is defined in the terms of the step by which the product is produced. This patent is in between a product patent and a process patent. Patent of addition. It is given to the patentee to make an alteration, addition or improvement of his patent. There is main invention. Normally, the term of such patent is the remaining period of the term of main patent. Then we will discuss what are the main objectives of the patent law. The objectives of the patent law is to encourage scientific research, new technology and industrial progress, because grant of exclusive privilege to own, use or sell the method or their product patented for the limited period encourages new invention of commercial utility. Then we will discuss the international law relating to the patent. The Paris Convention 1883, the Paris Convention for the Protection of Industrial Property 1883 dealt with the production of industrial patents, industrial designs and trademarks. It provides a separate international bureau commonly known as the International Bureau of the Paris Union, which was established to administer Berne Convention in 1893 and functioned under the various names, the most recent being the United International Bureau for the Protection of Intellectual Property, known by its French acronym BIRP, which administered these two treaties in 1960. It is important to note that Paris Convention for the Protection of Industrial Property has made a number of provisions for the protection of patents in the countries which are the members of the Union. Then the World Intellectual Property Organization 1967. It was signed at Stockholm on 14th July 1967 and came into force on 1970. The headquarters of WIPO are at Geneva and is on the specialized bodies of the United Nations. There are some main objectives of this treaty: the promotion and protection of intellectual property rights throughout the world through the cooperation among the member states and where appropriate in collaboration with other international organizations, to make the international law regarding IPRs, to bring national laws in tune with the international law relating to IPRs, to provide cooperation to the countries, administrative cooperation among the unions, disseminating information and maintain services for the protection of IPRs. International Convention for the Protection of New Varieties of Plants 1961. Though it was signed in 1961, but it came into force in 1968. It created a body called the Union for the Protection of New Plants. India is also a member state of this convention. Earlier efforts has been made by the developed country to extend IPRs to the area traditionally considered out of the boundaries for the IPRs. But the creation of the UPOV changed this position and established a system of international protector for the breeders of new plant varieties. However, the 1991 amendment went against the interest of developing countries because breeders were prevented from overlapping new varieties from those varieties already protected under UPOV. Worse still, the other part of amendment did not allow farmers to save the seeds for the next crop, as it was said to affect the legitimate interest of the plant breeder. Then there is the Patent Cooperation Treaty in 1970. It is a special agreement under the Paris Union and any member of the Paris Union may become its member. BIRP prepared the draft of an international treaty in 1967, which was revised by the Committee of Experts and was signed at Washington in 1970. This treaty, known as Patent Cooperation Treaty, entered into force on January 24, 1978 and became operational on June 1, 1978 with an initial 18 contracting states. The main objective of PCT was to simplify the procedure for filing patent application in a country which is a party to this agreement. Basically, PCT is not a competition with the Paris Convention, rather it supports the convention by making the patenting system more easy and more economical for the patentee in the countries which are the members of the Paris Conventions. There are some other important conventions, which is the Rio Convention on Biological Diversity, Eurasian Patent Convention, Trade Related Aspect of Intellectual Property Right Agreement 1995. Now we will briefly discuss the patent laws in India. The first act relating to the patent in India was passed in 1856 and granted inventors a monopoly for the period of 14 years. In the later part of the 19th century, new invention in the field of art, process, method or manner of manufacture machinery and other substance produced by the manufacturer were on the increase, and the inventors become very much interested that the inventions done by them should not be infringed by anyone else by copying them or by adopting the method used by them. To save the interest of the inventors, then the British rulers enact the Indian Patent Designs Act 1911. Since then, due to the substantial changes in the political and economic conditions of the country, it was found desirable to enact comprehensive law on the subject. Therefore, the Patent Act 1970 was enacted in 1970. Subsequently, the Patent Act 1970 was amended by the following. The first one is the Repealing and Amending Act 1974, the Delegated Legislation Provisions Amendment Act 1985, the Patent Amendment Act 1999, the Patent Amendment Act 2002 and the Patent Amendment Act 2005 and the Patent Amendment Act 2002. Major changes were made by the Patents Amendment Act 2002, which was passed on June 25, 2002, aligning it to the TRIPS in many aspects. The important feature of the Patents Act 2002 Act now provides for uniform protection for 20 years from the date of application for patent. Then publication of application after 18 months, whether or not application is accepted. Appellate board is established, therefore appeal against the order of the controller and central government and application for rectification of registered of patents will be to the appellate board and not to the High Court. However, suit for the infringement of patent or revocation of patent will be with the court only. Then the persons other than patent holder is to obtain marketing approval from regulatory authority within 3 years before expiry of the term patent. Provisions for the protection of biodiversity and traditional knowledge were laid down. Procedure simplification of international application under PCT and also an application before control in India can be filed simultaneously. Penalty for unauthorized claim of patent price increased to rupees 10,000 and penalty for refusal or failure to supply information is increased to 20,000. The Patent Amendment Act 2005. This Amendment Act was made to make Indian patent law TRIPS compliant. The important feature of the amendments are as follow. The first one is provisions in respect of process patents regarding food, medicine, drug, etc. are abolished. Provision in respect of EMR, you can say exclusive marketing rights, are abolished. Chapter 4A consisting of section 24A to 24F omitted, but applications already filed will be valid. All rights will continue and applications will be treated as application for grant of patent. Section 78 of the Amendment Act, there will be no acceptance of specification, provision of acceptance of specification and its advertisement have been deleted. Section 22 to 24 omitted and changes made in other provisions. Application for the patent will be published and can be made. However, hearing will be given if requested. After grant of the patent, opposition can be made within 12 months. A resident in India cannot apply abroad for any patent without written permission from the controller. Assignment of a patent is valid even if not registered, but registered of assignment of patent is still required. Suit for the infringement of patents cannot commence before the date of publication of the application. Provision for selling of patent is omitted. Provision for advertisement and notification in official gazette is replaced by the publication in official journals. Penalties are enhanced substantially. According to this Act, a patent will be granted if the invention in respect of which the patent is sought new and useful. Indian law in favor of the copyright protection and a computer program. In India, IT industry has witnessed tremendous growth in the past decade. resulting in large IT companies, inception of several promising startups. In the initial phases, the IT industry was largely focused on offering services. However, eventually several companies started creating software products. Companies that create software products thrive on innovation to create a unique product to counter competition. Hence, the desire to protect such innovation through patents and sustain competitive advantage. Indian Patent Acts offer protection to product or process as long as they do not fall under non-patentable subject matter. Section 3 and 4 of the Indian Patent Act specify a list of subject matter that is not patentable. Section 3 subclause K of the Indian Patent Act, which is provided below, is of specific importance to the software innovation. Then first we will discuss what is not invention. The following are not invention within the meaning of this act: a mathematical or business method, computer program per se or algorithm. Amateur offer refers to the above section and states that none of the software innovations are patentable in India. However, the reality is far from such perception. Not all software innovations fall under section 3K. Hence, a wide range of software innovations are patentable even in India. Having said that a wide range of software innovations are patentable in India, one has to be aware that almost all patent applications for software innovations are initially objected by the Patent Office citing section 3K. However, if the application for a patent is crafted intelligently by understanding the Indian patent prosecution practice, one can successfully obtain protection for software innovation. One of the keys for the successfully having a patent granted for the software innovation lies in the ability to present the innovation in such a way that the innovation which we are aiming to protect includes subject matter which is not a computer program. Further, subject matter is not just a computer program, should be intelligently made an essential part of the invention without compromising on the scope of the protection. Under Indian law, section 14 of Indian Copyright Act, which was amended by the Copyright Act of 1994, provides that computer program is covered under literary work under section 2O and section 2 FFC defines the computer program as a set of instruction expressed in words, codes, schemed or in any other form including a machine, readable medium, capable of causing a computer to perform a particular task to achieve a particular list. Further, under section 3K of the Indian Patent Act 1970, computer program is considered to be non-patentable invention, which provides that a mathematical or business method or a computer program per se or a algorithm are non-patentable invention. New guidelines regarding patent in computer programs. Indian Patent Office has come out with new guidelines for its officials to follow when deciding on application relating to the software and hardware related invention. In place of an earlier guideline which was kept in abeyance by the Patent Office, the following protest from some of the IT groups. The new guideline says that if the contribution of the invention lies only in the computer program, the examiner should deny the patent claim. The groups which raised protest against the previous guidelines issued in August 2050 hailed the new guidelines, stating that this is the line with the intention in the rules that patent should not be allowed to the software and its improvement. As per the new guidelines for the examination of computer related inventions issued from the Office of the Controller, Journal of Patents, Designs and Trademarks on February 19th, the examiners has to rely on 3 stages test in examining CRI application, starting with properly construing the claim and identifying the actual contribution. It says that if the contribution lies only in the mathematical method, business method or algorithm, deny the claim. But if the contribution lies in the field of computer program, checked whether it is claimed in conjunction with the novel hardware and process to other steps to determine patentability with respect to the invention, it says the computer program in itself is never patentable. If the contribution lies solely in the computer program, deny the claim. If the contribution lies in both the computer program as well as hardware, proceed to the other step of patentability, it added. This is expected to ensure that the application for patent in the field of software will be rejected and only application claiming a novel hardware component along with software will be eligible for patent protections. Says the advocacy groups opposing software patents in India. The aim of guideline is to bring in uniformity and consistency in examination of patent applications in the field of CRIs by the Indian Patent Act Office. The objective is to bring out clarity in terms of exclusion expected under section 3K so that eligible applications of the patents relating to the CRIs can be examined speedily, it says. Section 3K of the Patent Act 1970 as amended says that a mathematical or business method or a computer program per se or a algorithm is not invention within the meaning of this act. The guidelines analyzes what the terms mathematical, business method, computer program, per se or algorithm means. When a patent application is examined, the previous guideline according to them suggested that some of the advancement in the software compared to prior art could also get patent. These guidelines were against the statutory provisions and could have resulted in flood of the patents being granted in the field of software, which would affect the Indian IT industry, especially the startups, they said. This could have created a large number of patent litigations related to the software in India. In concluding remarks, I must say a patent is a set of exclusive rights granted by the government to a patentee for a fixed period of time in exchange for the regulated public disclosure of certain details of device, method, process or composition of matter known as invention, which is new, inventive, useful or industrially applicable. The business software patents can be acceptable via media or solution could be the development of different system of protection developed solely for and in respect of the software industry. Thank you viewers for watching this program.